time on that. The second point I thought I needed to make in terms of introduction is also just to bring a bit of my own experience in terms of relating to judges. And I'm very grateful to people like Justice William Ouko and others in the Supreme Court and in the Court of Appeal and the High Court and the magistracy who have humanized the judiciary. The judiciary has human beings. They are judges, yes, they are High Court, Court of Appeal, Supreme Court judges, but they are human beings and they are very humorous. They are very intelligent people. I think the selection process makes sure they are extremely intelligent people. They are also very humane. They are very kind and very caring people. And so they struggle to make these decisions. Now, when I served, I was just discussing this with Justice William Ouko a moment ago. When I served at the Office of the Chief Justice, supporting the Chief Justice, one of the frustrations was that the media did not seem to understand what the courts were saying. So one of the innovations that the courts had to do was, and I think Justice Ouko will probably bear me out on this, is the courts began to write something called media summaries, because they were so tired of journalists getting facts wrong, or rulings, that over and above a judge or a magistrate writing their decision, they would actually go the extra mile and say, okay, for public consumption, let us just explain ourselves. And then they will provide a 1-page or a 2-page summary of their reasoning and their decision and the outcome. I know that a lot of other things have happened, and there's also capacity within media organizations in terms of coming up to meet this new challenge that the new institution presents. And so I'm very glad and very grateful to be here in a very privileged position as a member of the Kenya Editors Guild to guide the discussion at the launch of the guidelines court report. At this juncture, I would like to request the next person on this. These are the people who have supported the Kenya Editors Guild and the stakeholder working group. Fatma Sambur from Internews to come and speak about what their thinking was when they decided to come and support this initiative. Is my friend on Facebook, and I'm meeting her for the first time. So glad to please, yeah, you can come and I'm not spat into the microphone, so you can come and use this. All right, yeah, karibu sana. Please come and tell us a little about why you wanted to do this and what you hope to achieve.
Okay, thank you so much, Bwana MC and my friend on Facebook, Omuchetsi Makoha. The guest of honor, Justice William Ouko, USAID's acting chief for governance, democracy, and conflict, the chief of party for the SEDS-K project, Phyllis Ombonyo, our media partners, the Media Council of Kenya, the Editors Guild, the Kenya Union of Journalists, the media space, ladies and gentlemen on site and online. Thank you so much, and good morning to all of you. My name is Fatma Sambur. I am the Senior Program Officer for Internews Regional Office here in Nairobi, and I am honored to be representing Internews Network in this event for the launch of the guidebook reporting. Before getting into the thick of things, let me start by talking a little bit about Internews, because I know sometimes we just assume that everyone knows about Internews, but let me speak a bit about what we do. So Internews is a media development organization, and currently we are based in over 100 countries. In Kenya, we've been in existence since 2003, and we've had several media programs. And back in 2003, 2005, we had our biggest health media project. It was called HMP. And I know majority of journalists online and on site do know our HMP project, because we were able to train around 900 journalists and supported several media houses on how to break down the science and the stigma around HIV/AIDS through accurate and factual health reporting. had several democracy and information that everyone can access safely, that consumers know how to critically access it, and that is valued. Reporting, a document that was reviewed or supported by Internews under the Safeguarding Democratic Space project in Kenya. This is part of our role in the project where we offer technical support to the local media sub-grantees that include the Media Council of Kenya, the Kenya Union of Journalists, the Kenya Editors Guild, who are our host today, the Bloggers Association of Kenya, and the Association of Media Women in Kenya, AMWIC. For the last 2 years, we have managed under this project to support the aforementioned media partners in not only activity implementation, but also building their capacity in the spirit of USAID's journey to self-reliance. Media in Kenya is transforming and at a very fast rate. And this transformation is not only in the embracing of digital tools of storytelling and information dissemination. Nowadays, there's something called specialized reporting, and this has also been normalized in several media houses. 10 to 15 years ago, we all know that this was not the case. Times, our media industry has seen the rise of specialized reporting. Nowadays, we have environmental journalists, we have health reporters, we have sports reporters, we have political reporters, and so on. This is really commendable. However, one thing that a specialized reporter will tell you is that all these specialized projects and reporting usually needs an extra time, an extra work, and actually they need to study more so that they're able to understand themselves and be knowledgeable before they can actually authoritatively report on the subject matter. With respect to the guidebook that is being launched today, it is evident that the media players in Kenya have recognized the need to have a vibrant reporting guide. This is in light of the sensitivity of court reporting. As a court reporter, one needs to understand the different structures in the justice system, the judges and their jurisdictions, the parties involved in any case, and most importantly and significantly, they need to tread carefully so that they're not found in any contempt of court. That is why we actually have this document in place now. The current guidebook that we are launching today, thanks to the Kenya Editors Guild, comes in handy as it complements the first document that was published in December of 1998 by the Frederick Ebert Stiftung in Nairobi. In fact, the review of this current document improves and aligns the court reporting guidebook to various statutes of the 2010 Constitution and also court reporting practices in Kenya and the Commonwealth. They are general in nature, so they can actually be augmented with other separate guidelines, for example, reporting children's court, reporting election courts, and reporting corruption and economic rights crimes reports. Internews is pleased to contribute in a small way towards supporting accurate reporting from the Kenyan courts. We believe that journalism is the center stone of humanity. We hold true in how we engage with partners and stakeholders that media needs to provide trustworthy, high quality news and information that people need to make informed decisions, participate in their communities, and hold powers to account. Well, with those few remarks, I would like to sincerely thank the USAID mission in Kenya, the chief of party of the SAID's-K project, the local media partners and individuals who have tirelessly worked to produce and make this document what it is today. And also I would like to acknowledge Rosalia Omungo and Abraham Marita, who have made this launch date a success. Thank you all and God bless you.
Please give her a round. You know, first I need to know that you actually had come with a written speech.
Yeah, I'm a journalist.
Yeah. Thank you very much, Fatma. And you know, sometimes when you're sitting there and you're wondering, you see some of those organizations like Internews, and you're struggling to understand what they do. I'm very grateful that you are able to explain what Internews does and what they have done so far. I want us now to jump right into. The launch of the court reporting guidelines. And the person who's going to speak next is, I see he has a name now that I'm not very used to, Erneo. I used to know him as Nyakundi Nyamboga. I used to know.
I'm at the office,
Yeah.
And James is here saying you guys are supposed to go for a physical meeting somewhere.
Yes, but it has been pushed.
Oh, so you should cancel that.
The sound system?
Yes.
So when? Okay, yeah. So what's the webinar you're going to?
Someone is addressing another meeting.
Yeah, kindly mute if you are following us online. Thank you very much. Please mute. Yes. So I was just about to introduce Erneo. I just learned when I began reviewing this guide that his name is Erneo, but I've always known him as Nyakundi Nyamboga. Nyakundi Nyamboga, for lack of a better description, is somebody I've always known as one of the finest and sharpest court reporters from my time in the newsroom. And you know, that's like eons ago. I'm a fossil. So I was in the newsroom something like almost 20 years ago. And that's when Nyakundi Nyamboga really was just shining in terms of being able to report courts very intelligently, very deliberately, and very accurately. And then, of course, he went on, studied law, did other things. He's now Dr. Nyakundi Nyamboga, which means that he has a doctoral degree, which helps us a lot, because now when he begins to help us in these conversations, you see we become a lot more erudite. This introduction is taking slightly longer than usual because I needed to be able to tell you that Nyakundi Nyamboga has also co-authored a guide. It's called Journalists and the Law with Professor Levi Obonyo. And so being here to help us do a guide to court reporting, I think is another step. And I think it demonstrates the greater good, which is that having one guide, you cannot have one guide and it's the be all and the end all of these discussions. So I just want to invite Nyakundi Nyamboga, Dr. Nyakundi Nyamboga, to give us a brief overview of this guide so that we know what we are looking at and what we are discussing.
Thank you so much, Komcheshi. I hope I can be heard. I am online. Can you hear me?
Yeah.
Thank you so much. My brief, I think, is to speak to the guideline, but let me recognize the chief guest. This is William Ouko and the rest of my colleagues. Now, the only thing Komcheshi did not say, and my employer would be keen to know, is where I work and what I'm doing when I'm supposed to be working for them. Department of Publishing Communication Studies. I could, as Makoha has rightly put it, I have a vast experience in court reporting, of course, beginning in the 1990s, all the way until 2010, when I hung my boots and decided to join the academy. I must thank the Kenya Editors Guild for picking on me to edit the guidelines. I am not the one who did the legwork. Of course, they will be acknowledged separately. All I did was to edit the guidelines. And of course, editing also includes reviewing and improving on it. Having said that, I will straight go to the guidelines and share with you what is in that book for all of us, not just for journalists who intend to cover courts, but for all people who have an interest in what goes on in courts, including, of course, journalism lecturers. And of course, this may not be said, but I think it's a good read even for judicial officers. It is important that the judicial officers also appreciate what the journalists think about their practice, and especially in the context of court reporting. In the book, which has 8 chapters, and appendices, which in my view would also pass for a chapter because they're quite loaded. The first chapter of the book basically talks about the relationship between the journalists and the courts. I think I don't want to preempt, but one of the things that it basically says is that the journalists have certain wishes that they would have expected the courts to do to make their work interesting. But they observe that sometimes some of the courts are a bit conservative. And when I talk about courts, of course, I'm referring to judicial officers, which is normal to be conservative. But there are also those who are also outgoing and open, who sometimes, allow the journalists also to have a good time when they are doing court reporting. And the most important part in that chapter is basically saying, is it possible that the courts can be as open as it can get to allow the journalists also got the information that they need for purposes of sharing it with the larger society. The second chapter basically is on my notes. The second chapter of the book is basically to journalists when they are in the courts bit. And the expectation is not any different from what we expect of journalists generally in their practice. So it has borrowed a few key aspects from the Code of Conduct for the Practice of Journalism. And the chapter has played up accuracy and balance in reportage. It also advises journalists on how to deal with the legal jargon, how they should, what kind of attire they should wear when they go to those courts, how they should address judicial officers. The same chapter also talks about what is expected of judicial officers. And again, it has borrowed from the Judicial Service Code of Conduct and Ethics. And one of the highlights in the Judicial Service Code of Conduct and Ethics is impartiality. Then we have chapter 3, which is basically on media access. Basically, it introduces new journalists or those who are practicing to certain guidelines referred to as coverage of court proceedings. Guidelines, the Judiciary Republic of Kenya, is a document that has come from the judiciary on journalists on the go on what they can do while in the courtroom or while in the court precincts. of the aspects that are played up in that chapter is, for example, can you walk into a courtroom and just begin recording, broadcasting, taking pictures, and so on and so on? Are there areas where journalists should not step, and so on and so on? Which is really very, very good information for a first timer in the courts, and even good information for those who have been reporting, but have, for lack of a better word, rusted, and they need to remove the rust. So there is no harm in a refresher course. So making a date with that chapter would be a move in the right direction. Then there's chapter 4, which in my view is the most loaded in the book, which basically introduces journalists to the local courts and the international courts. This is, in my view, is something that we all need to take time, whether you are reporting courts or reporting elsewhere. Could be an editor, but I think you also need to familiarize yourself so that it's clear when you get copy from a reporter, you know where it is emanating from. Because the chapter also has many other issues, including on who sits where. For example, if you're talking about the municipal courts, you're talking about the superior courts and the subordinate courts, the tribunals and quasi-judicial bodies. So it really gives you an idea who sits there, what the jurisdiction is, and so on and so on, which for me is very interesting read, and I think everyone else would find it interesting. Of course, it crosses the boundaries from the superior courts, subordinate courts, tribunals, and quasi-judicial bodies to international courts. And of course, some of the international courts discussed there are the East African Court of Justice, the COMESA Court of Justice, the African Commission on Human and People's Rights, the International Criminal Court, and the International Court of Justice. Again, it is detailed. It tells you what matters they handle, where these courts sit, who comprises those courts. Of course, it is supported by what we'll later find in the appendices, where actually the current office bearers or those who sit in those courts currently, their names are spelled out clearly, and even those who used to serve there but have since retired, you'd find that, of course, in the appendices, which comes after chapter 8. In chapter 5 of the book, again, a very important aspect is played up, which is basically the process of the courts. And again, here we have the criminal process and we have the civil wrongs process. So the chapter introduces journalists to the role of the prosecution in, for example, in the criminal court process, the role of litigants in the court process in criminal matters and civil matters, the role of judicial officers in criminal and civil matters. Then we have chapter 6, which also which merely lists relevant laws that a court reporter needs to familiarize himself with. And it lists, and the explanation for the listing is that other books or there are other publications which have dealt with, and I think in this case, they are making reference to courts, journalists and the rule of law. One of the publications that was, one of the first publications that is based on the Constitution of Kenya 2010, in that it has a litany of the media laws of the country. So those laws are merely listed in chapter 6. So a court reporter or any journalist will be expected to look at journalists and the rule of law, just to have a summarized version of some of those acts. But again, it doesn't stop anyone from going to the website to pick the country's law practice. Administrative Action Act. I'm sure it's suggesting that you need to study them the way a lawyer would, but I think it is important to appreciate the stance of most of those laws. Again, in the same chapter, it puts everyone else on notice that courts expect journalists to respect them. Of course, here we are referring to judicial officers in terms of their directions, in terms of their orders. Says content of court, and it's just a reminder to us that courts have teeth, they can bite if you cross the line. Maybe now that we have Justice William Ouko in the House, I don't know, he may want to say whether there will be a waiver for journalists who show disrespect to courts of law. But as the law is now, if you show disrespect to the courts of law, they will punish you for contempt. Again, that is discussed in chapter 6. Then chapter 7 of the book takes us through credible court documents and sources of information that a journalist may access. For instance, it says a journalist can access evidence introduced in open court, except where the privacy rights of the victims and concerns of family members outweigh the right of the public to have access. Of course, from that chapter, it is clear that you can't access every document. There are documents that you may not access. Of course, other documents that can easily be accessed include the court docket, the court lists, documents filed in pre-trial proceedings, pre-sentencing and post-sentencing reports, plea agreements, information, indictments, search warrants, supporting affidavits, evidence, and other materials related to sentencing. I think for us, it is important to know which documents we can access within the law and which ones we are prohibited from accessing. And again, at every instance, we must always remind ourselves at what stage is the matter, so that when we make reference to some of those documents, we don't take over the role of the courts in determining the guilt or otherwise of anyone who is before them. And then, of course, there's chapter 8, which is the last chapter of the book. The chapter, I must say, and a very good chapter. Sorry, there's noise in the background. I don't know whether it's coming from me or elsewhere. Okay, sorry about that. Chapter 8, again, very loaded, as I have already said. It is one chapter that if you are getting to the courts for the first time, perhaps you might want to look at. It basically gives you tips on how to pen a court story. It also gives you tips on how to conduct yourself as a reporter when you are covering matters involving children, basically coverage of the children's court. And then, of course, the other aspect that it talks about is if you must criticize the court, how far can you go in criticizing the court? Of course, it tells you that don't cross the line, because again, if you want to scandalize the courts, then of course that will attract reprisal from the courts themselves. And of course, it also talks about protection of sources. Can you protect sources? Can you get information and then promise sources confidentiality and so on? Are there circumstances under which courts of law may ask you to disclose the source of your information? And if the courts of law did that, is that then anchored in the Constitution? How do you balance the requirements of the Media Council Act 2013, the second schedule, which is basically the code of conduct for the practice of journalism, and the constitutional provisions in terms of access to information? You find that in chapter 8. Then, of course, finally, we have appendices. loaded. The appendices give you examples of the good and the bad in court reporting. Some 2 or 3 stories have been picked just to illustrate to you how to do a good story and sorry, what counts for a good story and what counts for a bad story, a bad court story. And of they have not, they have given you a link. You can read the stories in their raw form and see whether the opinion they have about those stories agrees with your opinion. And then, of course, in the appendices, you will find the names of the current judges and some magistrates and their workstations. Then finally, you find select legalists, words that are commonly used in court documents, words that are commonly used in courts of law, and may not mean the exact thing that we know in our day-to-day lives. And of course, there is the list contains terms that are in Latin. And of course, as I said, courts are still very conservative. They still use Latin terms. But at the time of doing whatever they do, I think they are not addressing Wanjiku. They are addressing the parties that are in court, and especially the lawyers. So terms would, Latin terms are in judgments, and therefore, as a journalist, when you're confronted with this, perhaps you don't have so much time to go searching what they mean. Then you have a one-stop here where you can quickly refer and see what probably the Latin term that has been used in the judgment means. That's what is in the book. And I must say thank you, and thank you, Kenya Editors Guild, for giving me a chance to edit and make this presentation. Thank you. Over to you, Kwamcheshi.
Thank you very much, Dr. Nyamboga.
Yeah.
We've allowed Dr. Nyamboga a little more time than everybody else because that's really the essence of why we're here. I now like to reject the program just a little to accommodate people who need to leave. So I know that the Vice President of the Kenya Editors Guild needs to speak next, but I'm going to reject that so that if Mr. Maina just allows me, I'm going to ask another Maina to speak in his place. This is my colleague, a longtime friend, and now my boss, Chair of the Media Council of Kenya, Maina Mwiruri. As Maina Mwiruri comes, and I tell you all these nice stories about our exploits in the newsroom together, is an important player in discussion for 2 reasons. One, they regulate the media space, but also Honorable Justice Ouko, you must know that the Media Council also houses a tribunal. And as we know from the Constitution of Kenya 2010, all tribunals are under the judiciary. So I think, Maina, I hope that intimidates you sufficiently so that you can take only 3 or 4 minutes to make your remarks.
Thank you very much, Kwamcheshi. My name is Maina Mwiruri. I'm the chairman of the Kenya. I acknowledge the presence of the president of the Appeal Court, Justice William Ouko, executives of the USAID, executives of Kenya Editors Guild, who have done a great work at this, and other supporters of this project. And I bring my humble greetings from the Media Council of Kenya. Before I'll keep it short, but Kwamcheshi, allow me to do this correction. It's not a tribunal at the Media Council of Kenya. It's a complaint commission. We are not at the level of tribunal. It's under constitution now. It had its time had lapsed. Right now, it's being reconstituted, and we hope it will do a lot of work. I'll not read a speech. When we were journalists, we used to fear long speeches. I'll keep it short and just glance at my notes. I was an editor for long. At one time, Kwamketsi was my boss. He was my editor. At the Standard, an editor at the People Daily. I was the managing editor at the People Daily. Dr. Nyakundi Nyamboga, I used to dispatch him to the court. To go. As an editor, I'll tell you that the court docket is an important constant, very important. Though you do not see a lot of it making the headlines, being a very political country, it's a very important docket. All editors will tell you what has been done today through the publishing of these guidelines has been long overdue. It's been long awaited. There are no court reporters who come to the newsroom and we know these are court reporters. Outing for an intern is courts. My first outing was courts to cover Koigi Wamwere. That tells you I'm older than Kwamketsi. You grow through the courts. Rarely do you get people who come and grasp it like Dr. Nyakundi Nyamboga, who come and become the expert. And through such people, they've elevated court reporting to a high docket in the newsroom. Despite it being the training ground for most journalists starting on this job, it's very crucial that it's perfected to become one of the leading brands in accuracy and balance required in court reporting is crucial for just as for other fields in journalism. However, when you sit as an editor, you realize that we know what happens in courts, but we do not know enough on how to cover the courts, and the media is many times just like a conveyor belt of what happens in courts. Sometimes readers read a story and they do not know what the reporter is saying. Until we got people like Dr. Nyakundi who brought into courts equal serious analysis like happens in politics. So that when you read it at the weekend, you can know, oh, this is exactly what the judgment meant. Apart from just being brought to court and being accused, it has increasingly now become a respected field that today, with the launch of these guidelines, we must always act responsibly as editors and reporters in respecting court reporting. I'd like to say that this launch of these guidelines is coming at a critical, crucial time. Has become freed, Kenyan media has become freed to completely and freely cover courts, and especially now corruption cases. In our time, you did not just cover what came to court. There are stories we brought to the newsroom and the editor pushed it slowly away. Not that it's not factual, but the times have changed. Media is now free, independent. Media now can cover, I do not know anything Kenyan media cannot cover. Indeed, now all we need is the guidelines. Even as you are so free to cover courts, this is the way it should be done. I'm glad to hear that Dr. Nyakundi has from a code of conduct for the practice of journalism in Kenya. In that, it is entrenched in the act. Part of it, like 10 bullet points, just dwell on coverage of courts. You'll be surprised that however elite some journalists may look, they do not know that you are not supposed to interpret evidence before it's tabled by a witness. It happened last week in a very dangerous way. But Justice Oko, these days courts do not summon editors and journalists. Times were when we used to be summoned. At one time in the newsroom, I want to cut this short, just acknowledging why these guidelines are so important. At one time in the newsroom, an editor dissected the judiciary with a headline, "Judicial Tyranny." Someone was nearly jailed. Maybe only Komchetsi could remember that. Another time, during the OUCO Commission of Inquiry, a commission is just like a court. OUCO was reported to have been summoned to State House. The editor decided to interpret it like Moi summoned OUCO. Later, we learned that State House is not Moi. The editor was summoned. Summoning OUCO to State House does not mean Moi summoned him. As a editor lost his job. Maybe these guidelines by Dr. Nyakundi now, editors will know how to cover courts, how to dissect court material, what to go into, what to avoid, and what to do with all the freedom we've got. And finally, we are working with the judiciary to try to tame a problem that we cannot cover up. Quack journalists covering courts, and not just courts, everywhere. What we are telling all departments of government is the Media Council of Kenya accreditation card is now foolproof. Do not allow journalists to cover such important functions without you asking them identify. So simple. And that card bears an identification. It's digital now. You can check and actually see, yes, these are journalists. We are having lawyers complaining. Parliament has now perfected it. No journalist without Media Council accreditation can enter Parliament. It should also be the same with the courts so that the complaints come down. Thank you very much, Komchetsi. And these guidelines, Dr. Nyakundi, we are very grateful. Thank you.
Thanks. Thank you, Maina. I would like to thank all of you who are in with us virtually, and to just encourage you now, just to enable us to manage the time better. I would like to encourage you to use the chat button on the side. If you have questions or issues you would like to raise with any of the people who are speaking, we can actually have a conversation running so that by the time then Justice Ouko comes and does the launch, then we will be able to make use of the time a lot better. Maina Mwiruri, thank you very much for those remarks. And I will keep on doing this as we go along in terms of just stringing stuff together. One of the frustrations I faced when I worked at the judiciary, the reporters are illiterate or they don't know how to report courts. But actually, that the editors who manage them are not as knowledgeable. And sometimes when journalists or reporters do a fair report, the editors who are hierarchically above them sometimes take it upon themselves and reinterpret what has been presented to them and then cause distortion. So although this guideline is a guideline for court reporting, I would like to encourage my colleagues that, and I'm glad that it's the Kenya Editors Guild that's at the front line of this, in terms of acknowledging that sometimes a lot of the errors are not because the reporting was bad, but it's because the editing distorted it. And so some minor, Vice Chair, I'm putting you in the hot seat as I call you up. Yeah. So come and defend us now as editors. Yeah, if you're available, please, it's now your turn. Yeah. Karibu sana.
Good morning, members. Morning, those who are online.
Morning.
I think we are in interesting times that we don't say hi to anyone. We say zile za wakolino, itosheka. But it is interesting time, and we are going to go with that until the situation improves. Chief guest, Honorable Justice William Ouko, President of Court of Appeal, my comrades, my colleagues from the media industry. I'm the Deputy President of the Kenya Editors Guild. Receive greetings from our members, many of them who are online. and our president, who would have liked to be here, receive greetings from him. Stories from courts have made good headlines for talk of Goldenberg and agro-leasing scandals or high-profile murder cases, such as the Naivasha, Lancha, Tom Chomley. They all provide captivating stories. More and more high-profile cases are being filed in courts across the country. Currently, at least 5 governors are facing graft-related charges in court. There are murder cases, such as that of Tom Cohen, Monica Kimani, Willie Kimani, his clients, Josephat Mwenda, and taxi driver Joseph Muiruri. The society expects journalists to tell exactly what happens in court, the accused person's evidence against them, and the court verdict. And the court verdict. The basics of journalism remains the same: reporting accurately, fairly, and without malice. Despite the demands of court reporting, training institutions do not offer courses on reporting from the courts. Most of the focus is and media ethics. Most newsrooms in Kenya have in the past built teams allowed experienced court reporters. Society. How will we simplify court stories without losing the meaning? All misreporting remains key. We owe it to our listeners, our readers. Finally, remember not to close the court's line. I'm sure many of you have heard about the rule of sub judice, a common law principle that generally prohibits public discussion on matters pending before the court. Publishing details about a crime or the suffering of a victim after someone has been charged could interfere with the court's job, might land you in trouble. I'm sure the guidelines we are launching today have more details, which will help court reporters navigate the corridors of justice. Thank you very much, and thank you for those who have worked on this. It's going to help the editors and the reporters a lot. Thank you.
Now, one of the things that many people don't know is that Sam Maina is a legend in broadcasting in Kenya. He's been at 2 stations, but since he's the president of the Kenya Editors Guild, let me not tribalize him by saying, whether he worked on at KBC or K24, because he takes care of all. As we go ahead, I would just like to acknowledge people who are in the room. Chairman of the Kenya Editors Guild Emeritus, Wangethi Mwangi, I would also like to acknowledge the chairman of the Kenya Correspondents Association, or William Olo, who's also like with us as we move forward. Please, I've seen some of you have already begun using the chat to raise questions. Please keep doing that. I will endeavor to connect them to the people who need to respond to them. Now, at this point, I would like us to listen to Phyllis Ombonyo. Phyllis Ombonyo works for Family Health International. And before she got there, as she just comes to take the microphone, Phyllis, I almost got a job at Family Health International in 1990. And no, 1993. And the only reason I never got that job was because I didn't know how to use a computer. And the big thing that they were on was that, well, the interview was they required you to switch on a computer and answer all your questions using the computer. Now, unfortunately, at the time, if you are using a computer, it was called a PC, personal computer. There was no mouse, so you had to do all those things and start with a C:\\, double backslash, Wordwin, and then launch WordPerfect 5.0. Now, I didn't know any of that. So I consider you family. So please come along. I almost feel like we worked together. If I had computer skills 30 years ago, we would have worked together. Karibu.
Thank you so much, Paul Makoha. It's a privilege to have you as the MC of this event. And let me just say that your dreams are valid. You can still work for FHI 360. That's what Lupita Nyong'o would say. Yeah? Okay, so the guest of honor, President of the Court of Appeal, Justice William Ouko, Chief Registrar in her absence, USAID's Acting Chief of Democracy and Governance, Madam Faye Hazelcorn, who's joining us virtually, the Council of Kenya, Vice President, Kenya Editors Guild, CEO, Kenya Editors Guild, Rosalie Omungo, who's here with us, the Senior Program Officer, Internews, and everyone else, ladies and gentlemen, and all protocols observed, good morning. It's a privilege to be here and witness this very important occasion. We do know that the relationship between the media industry and the judiciary is complex. And I think many of the speakers who came before me alluded to that. In its watchdog role, the Fourth Estate is sometimes at loggerheads with the courts as it seeks to play the oversight role delegated to it by the public. And the two arms are allies because the media improves the people's understanding of court processes, helping to build trust in the judiciary and its decision as an impartial arbiter. Between freedom of expression and the administration of justice can affect the quality of our democracy. It is in our common interest, I believe, that the media and the courts can play their independent roles to ensure Kenya's democracy thrives. Indeed, this vision is one of the driving forces for the existence of Safeguarding Democratic Space in Kenya, which is the project that I'm responsible for. More broadly, SEDSK, as we call it in short, is an FHI-led USAID-funded project which supports the Kenyan government and civil society community to strengthen the governance reform agenda and to secure democratic gains enshrined in the 2010 Constitution. SEDSK promotes national dialogue and governance reform, and our interest really is to ensure that the governance reform agenda is not elitist, but that everyone gets an opportunity to voice their opinions. Social cohesion, we safeguard democratic space through support to independence and professionalism in the media and the rule of law processes. Ladies and gentlemen, we recognize that independent media plays a critical role as a source of information to empower the citizens to participate effectively in public affairs. It also serves as a watchdog, a guardian of public interest, and a vehicle through which citizens hold duty bearers to account. To media, as SEDSK is grounded on the pressing need to safeguard the crucial role of media in the context of increasing challenges that threaten to restrict the capacity of the Kenyan media. In recent years, you'll agree with me that the Kenya independent media have experienced economic pressures that have reduced operational capacity and profits, resulting in high staff turnovers. We've all witnessed that. And more recently, the COVID-19 pandemic has resulted in further layoffs affecting journalists. We reached out to our partner MCK the other day, and they confirmed to us that from January to date, up to 600 journalists have been laid off. So that just goes to show how bad the situation is. This really threatens the continuity and overall effectiveness of the media. The situation is further exacerbated by the rise of social media and citizen journalism, which calls for drastic re-engineering of the mainstream medium for it to survive. And the upheaval in the media landscape comes as the sector continues to receive severe scrutiny, with the ever-increasing expectation on professionalism. SEDSCAI, therefore, supported the development of these court reporting guidelines to promote professionalism as well as sustainability of Kenya's independent media. At SEDSCAI, we see professionalism as being one of the best ways to enhance the media freedom, which we all desire. Various initiatives co-created and led by local actors to strengthen the crucial role of media. This includes grants to promote journalistic integrity and self-regulation, to combat disinformation and hate speech, and to enhance media management and financial sustainability. In addition to the Editors Guild, who are the ones who have brought us here today, the other media recipients of SEDSCAI grants include the Kenya Union of Journalists, the Association Media of Women in Kenya, the Bloggers Association of Kenya, and the Media Council of Kenya. Recognize the efforts by Internews that has been working tirelessly to provide technical support to all these media entities, as well as our other partners. Partners have collectively received financial support from SEDSCAI to the tune of 63 million Kenyan shillings. And I must once again appreciate USAID for this generous support, without which this program would not have been possible. This support mainly goes to increase the resilience of the media in the face of the unprecedented challenges that I talked about earlier. I am glad to note that some of the efforts have institutional capacity, resulting into a stronger drive to reforms in the sector and contributing to innovative sustainability schemes like the recently launched Media Sustainability Fund, which I know is a key priority for the Editors Guild. And so in conclusion, let me reiterate that we believe support to professionalism translates into a better position for the media to self-regulate, to assert their independence, and more effectively play their rightful role in protecting democratic and civic space and to promote the rule of law. So hongera to the Kenya Editors Guild and everyone else who made it happen. The Media Council of Kenya, this is a really remarkable achievement. Success as you begin to roll out these guidelines to the entire media fraternity towards a better Kenya. And to all those who have joined us, I would wish to leave you with a quote from one man whom we highly respect, Nelson Mandela. This is what he once said: "For to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others." Thank you very much.
Thank you very much, Phyllis. To work at Family Health International. The reason for that are generational. We are trying not to take jobs from people that are younger than us. Moving along, as I also acknowledge other people who are in the room, I acknowledge the presence of George Nyabuga, professor at the School of Journalism, University of Nairobi. And as I invite, her name is a bit challenging, Faye Hasselcom, who is the acting chief of democracy, governance, and conflict And I see that she has brought with her people from her office to support her. I see also online that my friend Zef Aura is also there. I invite Faye from USAID to kindly speak to us about the involvement in this project. Yeah, vision. Karibu sana.
Thank you very much for the honor to be with you today. Can everybody hear me?
Yes.
Yes.
Okay, great, thank you. So guest of honor, President of the Court of Appeals, Justice William Ouko, the Chief Registrar, Judiciary of Kenya, Ms. Anne Amadi, the Media Council of Kenya, represented by Mr. Maina Mururi, the Vice President of the Kenya Editors Guild, Mr. Samuel Maina, and the CEO, Rosalia Omunga, the Chief of Party for Safeguarding Democracy in Kenya, Ms. Phyllis Ambonyo, and the Senior Program Officer for Internews, Ms. Fatma Sambur, all protocols observed. Hamjambo. Ninafurahi sana kuwa pamoja na nyinyi leo. My name is Faye Hasselkorn, and I work for United States Agency for International Development. I'm joining you, as was stated today, with my colleague, Mr. Zephaniah Ora. We really have a lot to commemorate on this day, which happens to be the International Democracy Day. Democracy is many things, not least of which is the ongoing quest by people around the world for democracy and freedom. That is what guides and inspires our work at USAID. Congratulations to the leadership of the media sector in Kenya for the great achievements they have made to inform Kenyans on key issues of national concern and to help set an agenda on governance, accountability, and human rights challenges for national discourse. And also just really congratulations for the great work on this toolkit. I think that's going to be an incredible resource for journalists and for the courts alike. The COVID pandemic has brought significant challenges to the media industry and the environment in Kenya. Both financial pressures and pressures on what to cover and how, threatening media sustainability. Media sustainability and media independence cannot be separated. And media independence is a central component of democracy. An independent media can provide unbiased, accurate, and impartial information to the electorate who must make their choice. Like other sectors in Kenya, the media has a role and a stake in the ongoing reform agenda at making Kenya's governance system more inclusive and accountable to the people. Your informative and agenda-setting role will be crucial as the country enters another phase of the BBI process and the 2022 electioneering period. Kenya continues to implement the 2010 Constitution, including devolution of power to local governments. Yet corruption poses a continued risk to the success of these reforms. The media has done well in exposing these concerns. The people and the governments of Kenya and the United States have a long and strong partnership built on shared values and mutual respect. These values include free media and professional journalism. Over the last 2 years, the U.S. Embassy Nairobi has provided 37 million Kenyan shillings to the Kenya Editors Guild Press Freedom Initiative to expand media freedom and independence in Kenya and to improve the professionalism of journalists, editors, producers, and all who investigate and report the news in Kenya. The U.S. Embassy Nairobi is in our 3rd year of supporting the Women in Media Mentorship Program, connecting experienced female journalists, editors, and producers with young women just starting in the profession. This past year, the U.S. Embassy has also partnered with the Kenya Community Support Center on a new grant to build the skills of young community radio producers on the coast to effectively cover stories on violent extremism and recruitment within their communities while expanding the reach of their programs. One of the United States' most important goals in Kenya is to partner with Kenya to realize the promise of democratic reforms, strengthening the rule of law, protecting human rights, and safeguarding civic space and media freedom. USAID is changing the way it partners with Kenyans and Kenyan institutions. We call this new way of doing business the journey to self-reliance. What this means for us is working in a very deliberate way towards a day in which foreign development assistance is no longer needed. It means that everything we do needs to be Kenya-owned, Kenya-led, and Kenya-managed. Kenyans and Kenyan institutions, this means bolstering their capacity and commitment for transparency, inclusion, and accountability to the Kenyan people. It is within this framework that USA government made resources available to enhance professionalism through a free and independent media that is accountable, to support the development of legal frameworks for the media, and to create a safe operating environment for journalists. We are proud to partner with FHI 360 and the Media Council of Kenya and their extended network in this effort. The US government acknowledges the commitment of Kenya and Kenyans and your leaders who've demonstrated a commitment to uniting the country following the divisive 2017 election. The US government stands with the government and the people of Kenya in this momentum reform process within the BBI framework. We are certain that reforms that are Kenya-led and Kenya-owned will be a success for all of Kenya. Thank you for allowing me this time to speak with you. And again, congratulations on this incredible resource for improving transparency of court proceedings and supporting journalists and the judiciary alike. Asanteni sana.
Okay. And your Kiswahili is great. Eh? Just the practice will help. So speak it as often as you have an opportunity. We are now at the moment. I don't know. We were expecting that Judge. We were expecting that the Chief Registrar, in following protocol, would be here to introduce you. I can't see my friend, the Honorable Chief Registrar. I will request you to please permit me to, to violate protocol a little and invite you. Justice William Ouko. Justice William Ouko is a very self-effacing man, but he's a man of very many accomplishments. So if you actually want to know, Justice William Ouko has served in the magistracy. He has been registrar of the High Court for very many years. I remember, I think when I was in journalism, that's where he was, basically running the entire court system in Kenya. That's what the registrar does. He knows there's no court that you can talk to him about that he doesn't, the location and how it looks and how many, whatever it has. And then, of course, he was appointed to the High Court and subsequently judge of the Court of Appeal. Now, this is not known to very many people, but Judge William Ouko is also my uncle. We are related. Yeah. I have people in high places. I know people in high places. No, I'm only pulling your leg. But he's a very amiable person. And when I worked at the judiciary and got an opportunity to see him at close range, he was one of my great protectors. So one of the things that I learned about Judge William Ouko is that he's very poetic. And so if you are actually looking for those occasions, if you are looking for those occasions that require somebody who chooses his words and knows just the right word for the right moment, that would be Judge Ouko. So I remember, I think we were honoring a retiring justice of the Court of Appeal, Justice Onyango Otieno, judge, if you remember, in Kisumu. And so he had this citation, and it was just one of the most beautiful things I have seen anyone ever turn out in a very, very short span of time. I'm telling you that because sometimes in the drab drudgery of doing judicial work, and I know that right now the Court of Appeal is extremely stressed. There are only, I think, 15 judges with 12 of them active, covering the whole country. So, you know, they get pressed. But when those judges do have a moment explaining, and I think I learned this from one of the judges, I think in the Supreme Court, that the most critical part of a judge's role, other than delivering justice, is also to explain to you why you have lost. Because sometimes people come and begin attacking the judicial system because their cases are not succeeding. I'm very grateful, and I think Kenya is very lucky to have people like Justice William Ouko, who can not just explain in prose, but they also explain in poetry. He has a lot of experience interacting with the media, both from an administrative role, but also as a judicial officer, and now as the president of the Court of Appeal. And I'm sure he has interesting perspectives in terms of how media relates to the judiciary and how it reports and what we can do with that relationship. Our chief guest, the Honorable Justice William Ouko. Karibu sana.
That didn't sound like myself being described, but I don't want to contradict him, because as he says, if he's my nephew, if I touch his ear, he goes deaf. So I will not thank you, Kwamchesi, for those very kind remarks. The Vice President of the Editors Guild, Samuel Maina, David Moyo, the Chief Executive Officer of the Media Council of Kenya, council members and trustees of the Guild, Rosalia Omungo, who received me when I got here, the Chief Executive Officer of the Guild, Phyllis Ombonyo, the Chief Family Health International. I found the title of the organization, the title rather interesting. Faye Heselkon, the Acting Chief Democracy, Governance and Conflict of the USAID, members of the Fourth Estate, and gentlemen. I didn't walk alone. I came with an officer from my office, Mr. Benjamin Kinuthia, is at the back. We support, moral support. I bring warm greetings from the Honorable the Chief Justice of the Republic of Kenya, who is also the President of the Supreme Court, the Honorable Mr. Justice David Maraga, on whose behalf I am here. For me, it's an honor to have been invited by you to make a few remarks as you launch the court reporting guidelines, which will no doubt go a long way in enhancing the quality and accuracy of reporting from the courts. Ensure that the media, as the fourth pillar of democracy, effectively plays its cardinal role of communication and education by providing the facts and opinions that shape perspectives on many topics of the day and also influence government action and public policy on critical issues of our society. Covering courts is an important task for several reasons. First, reporting court cases fulfills the part of the watchdog function of the media. Secondly, there is a great deal of public interest in what the courts do, both in criminal and civil cases. Coverage of the courts can also expose unfairness in the system, either for accused persons, victims, or parties generally in a dispute. May also help prevent injustices by shining spotlight on the actions of judges, lawyers, prosecutors, parties, and other participants in the justice system. Despite the importance of courthouse reporting, judges, lawyers, and members of the public often complain about reporting that is inaccurate, biased, or short on content. To some, this is because those sent by media houses to do stories about cases in court have no or little training about the complexities, the processes of the court, and its terminology. Some do not take time to understand the facts and how the law has been applied to those facts. Of appreciation of basic things like the structure of the judicial system of the court. And I'm glad, looking at the guidebook, that the structure has now been spelled out for the reporters. There are, in addition, isolated instances of laziness and shortcuts, where reporters merely rely on third parties for their stories without verification with the source, or by drawing conclusions in matters that have not been tried and determined on merit. And I want to draw two instances, most of them quite recent. The first one is where there was a report in the newspaper of an outcome of an appeal whose judgment was yet to be delivered. And the question we asked, where did you get the judgment? Of course, I think it is Dr. Nyamboga who said that these days things have changed. In the past, the author of that story would have been someone to come to court to explain the source of that story. Quite embarrassing for the judges who are involved. They were still in the process of drafting the judgment, but here it was in the newspaper with the details of the parties and what the court said and how one party lost. That was not a very good thing. So what happened? The three judges recused themselves and the matter had to start afresh. Again, delaying the matter further through careless reporting. Where there were many parties involved, several in hundreds had sued an institution of government, making some claims, and they won the case, but the newspaper reported that they had lost. So you can imagine what happened to those thousands of people who had sued, reading in the papers that they had lost, yet they had won the case. Stories obtained and disseminated recklessly without ascertaining their correctness have attracted civil litigation, as has been said here by those who spoke ahead of me. This has led to media houses paying colossal sums of money in damages for misreporting, which were seen as defamatory. A small story occupying less than quarter page, an award in damages of 6 million is not a joke. If you are a reporter and you are making the media house for which you work pay 6 million for your reckless reporting, if you are to be dismissed by the media house and you came to court this is a joke, to ask to be reinstated or to ask for damages, the court might not sympathize, because courts also are victims of misreporting, and courts are presided by human beings who will, in the instance in question, may feel biased against you. So we must always remember that whatever we report must be accurate. You must be in a position to defend it with facts be very, very careful. Issues of content also come to mind, that if you report something that is not true, or if you scandalize the court in the manner in which you report, that you can actually be cited and be committed for contempt. Be you as the reporter. This again, as Dr. Nyamboga talked about it, has gone down. We do not have many journalists being committed for contempt of court. The last major one was in 1994, if you can all recall, and David McCulley, contempt that was tried in the Court of Appeal. I say it's an unfortunate blot in our jurisprudence. It was a matter, if tried today, perhaps they would have been just warned if they were found to have made a wrong report. Article 50 of the Constitution of Kenya grants every person the right to a fair trial. It is therefore important that reporters covering court sessions adhere to professional excellence by observing the basic tenets of journalism, which include accuracy and checking for facts to avoid a possible conflict between freedom of the media and the rights of a fair trial parties. In addition to this, and I believe the guidelines have adequately addressed it, and I've also had a speaker talk on the question of sub judice, a rule which regulates the publication of matters which are under consideration by a court if the publication creates a substantial risk that the course of justice in the pending proceedings would be impeded or prejudiced. We in the courts have our own share of blame. We make comments that are unnecessary, but which convey an unintended message and which may be taken to point to the direction of the ultimate outcome. Ruling on bond, for example, the court cannot be had to hypothesize on how there is a certain trend of committing certain offenses by members of the family, and how it is our duty as a court to punish those involved. Last week, and I couldn't believe that at the point of ruling on whether to grant bail or not, the officer goes on to say stories about how there's a trend nowadays in the country, families are involved in committing certain crimes. That, to a layman, would convey the message that this person before this officer, his goose is cooked, because the officer has already said, you and your wife and your children, we are seeing this very often, and therefore you must have done it. We are not supposed to make such remarks. Such remarks, if at all, can only be made at the conclusion of the trial and when a basis has been laid for drawing such conclusions. Why do courts like the use of legalese in their decisions? Yet a large majority of those to whom those decisions are meant are not versed in technical legal language. Again, this is addressed in the guide. We'll hear and read words and phrases, which again have been defined in that guide, words like de novo, that the three judges who recused themselves had, through that recusal, the cases, or rather the matter had de novo, but I decided to use the word afresh, because that's what it means. So why do we use words like inter alia? Why do we use a fortiori? Why do we use ab initio, compos mentis, justem generis? Why do we use this to litigants who really do not understand this? They don't even care what they mean. They just want to know in a simple language what you are communicating through your decision. Words other than anything else, are capable of causing serious confusion and even to those who are learned in other fields. Why judges speak softly? I mean, in court, not out here. If you meet a judge in a podium like this, you can hear me. Sometimes in social places, you can hear judges, really talking loud. But when you go to court, they just murmur. And have you ever asked yourself, why do judges speak in low tones in court, even when something is so serious? I have no answer why they do that. But I know that many people leave courtrooms and ask what transpired. Even when the proceedings, even when the judgment was read in a language that they understand. Ask, what did the judge say? But they sat in that court and listened through the delivery of the judgment. Our own Directorate of Public Affairs and Communications at the judiciary have been very useful or helpful. It has not been very proactive in helping reporters and the court in providing what Konsesi talked about, the summaries of the court decisions in controversial matters or in matters of public interest. We have a directorate. We only see it when it sends a summary of media, daily media reports, newspaper reports. We only see it when we have a complaint that we have been misreported in our decision. Time to engage the media at the time delivered. They do not provide summaries, although in many courts, summaries are now provided, like in the Supreme Court. They summarize for you the judgment so that you do not make a mistake if you do not understand it. It is because of the above and many other challenges confronting court reporters in the course of their daily work that I highly commend the Kenya Editors Guild for taking this initiative to review and update court reporting guidelines in order to promote reliable reporting from the courts. With these guidelines, journalists covering the court beats will be fully equipped with the requisite resource and tool. The guidelines present a learning opportunity for reporters. It remains a technical area which requires constant reading. Indeed, apart from reporting in a war zone, court reporting may actually be the most demanding assignment for a reporter. For court reporters to acquaint themselves with the court system, language, and procedures to effectively carry out their duties. It's not a simple pen and pad affair, although, as I said, it's perhaps next to a war zone, and that's why I think those who spoke earlier said the first place you are sent perhaps is the court to go and war zone. And so it's not a pen and pad affair. You have to understand the procedures, you have to understand of the court. It will be observed that these guidelines are being launched in the midst of a global pandemic, COVID-19, which has created a disruption in the traditional media as we know it, and has led to the growing social media as a purveyor of news and information. However, the need and the duty of journalists to report accurately and to verify facts before going to press remains. At all times, court reporters must be prepared in the discharge of their work to stay on the straight and narrow path of the many offenses created under the Kenya Information Act and to abide by the edict of the provisions of the Media Council Act. Challenging times have driven all of us to shift to a new normal. The judiciary has made adjustments to ensure the workflow in the courts is not interrupted for both judicial officers and reporters. We therefore endeavor to provide conducive working environment for reporters like the media center at Milimani Law Courts to be replicated in all court buildings in the major cities. As the courts continue to conduct business largely on remote platforms, to be part of those proceedings by being invited to join the video links. Colleagues, the judiciary is committed to protecting the rights and fundamental freedoms guaranteed to the media in Articles 34 and 35 of the Constitution. But remember the limitations, especially that in the exercise of your rights, also respect the rights and the reputations of others. We shall continue to work together for the benefit of the people we serve. And today's launch of the guidelines heralds the next most critical phase to train and sensitize the end users of the guidelines. The judiciary, through the Judiciary Training Institute, is ready to partner with the Guild in this initiative, which hopefully can be carried out in all the counties to ensure uniformity. Colleagues, I wish to congratulate the Kenya Editors Guild and the project partners initiative and for inviting the judiciary to be part of it. I thank you all for listening to me, and with that, I formally launch the guide to court reporting in Kenya. Thank you.
Thank you very much, Judge Ouko. I will now invite Rosalia, Phyllis, Fatma, to